Well, thank you, Mr. Speaker. It's my great pleasure to rise today to speak in support of Bill C-23, the Fair Elections Act. If I may, I'd like to take this opportunity to outline how this bill will be of great benefit to our democracy. Mr. Speaker, our government understands that the integrity of Canada's voting system is paramount to our democracy. It is vital that we protect the integrity of the system so that everyday Canadians remain in charge of our democracy. That's why, Mr. Speaker, the Act has been met with support by Canadians from coast to coast to coast. My honourable colleagues have spoken at length about the many facets of this landmark legislation. The Fair Elections Act will ensure that our elections are fair and democratic. As members of all parties, we are entrusted by Canadians to act in the interest of protecting the integrity of our electoral process. The Fair Elections Act, Mr. Speaker, provides all members an opportunity to uphold that obligation. I'd like to add that the government undertook extensive consultations in drafting this legislation. The bill brings to light concerns raised by Canadians, various groups and think tanks, Elections Canada, and parliamentarians themselves. The Fair Elections Act addresses those concerns and would improve the system by introducing a new standard of consistency. We promise to examine the bill with openness to ideas that would strengthen this common-sense bill. That's why, Mr. Speaker, on April 25th, the government announced it would support the amendments to the Fair Elections Act. The committee has had a long and extensive study of Bill C-23. There have been 15 meetings, amounting to roughly 31 hours of study. In addition, there have been 72 witnesses that appeared at committee to offer insight into how we could further strengthen this bill. I'd like to begin by discussing the issue of vouching. First, I want to emphasize an important element of the Fair Elections Act, which is the changes that it will make to the identification process. As it stands, the current system has been unable to preserve the integrity of the electoral process. In fact, Mr. Speaker, serious errors of a type the courts consider, quote, irregularities that can contribute to an election being overturned were found to occur in 42% of cases involving identity vouching. Overall, the Neufeld report estimates that irregularities occurred for 1.3% of all cases on election day voting during the 2011 federal election. More than 12 million Canadian citizens cast ballots, and the audit indicates that the applications of specific legal safeguards in place to ensure each elector is actually eligible to vote were seriously deficient in more than 165,000 cases due to systematic errors made by elections officials. Averaged across 308 ridings, elections officers made over 500 serious administrative errors per electoral district on election day. These levels, Mr. Speaker, are just too high. We must recognize that a fraudulent or illegitimate vote has the same mathematical effect as denying honest Canadians their constitutional right and privilege to cast a ballot. The Neufeld report cites cases of fraudulence and irregularities that are far too high. We cannot let the electoral system continue in its current flawed trajectory. That's why the Fair Elections Act will finally end the use of vouching as a means of identification. Our government believes that it is important to let every eligible voter cast a ballot. By the same token, we believe that fraudulent voters should be ineligible to cast a ballot. The safeguards that current laws establish to halt fraudulent voters were violated in 50,735 cases, 42% of the time, in the 2011 election, according to Election Canada's own compliance report. We cannot continue to abide by the current vouching procedures and expect different results in future elections. It is evident that changing times have brought about changing threats to the integrity of the electoral process. That's why, Mr. Speaker, I'm pleased with the direct manner in which the Fair Elections Act proactively keeps up with changing conditions. Mr. Speaker, the Fair Elections Act represents a giant leap forward in ensuring that the integrity of the electoral process is upheld. The bill will require voters to choose from some 39 pieces of acceptable identification to prove their identity and residence. Photo ID will not be required. Again, photo ID is not required, but simply having someone vouch for a voter's identity with so much as a utility bill to back it up will no longer suffice. While the Fair Elections Act will require people to show ID excuse me, proving who they are before they vote, we support an amendment to help people whose address is not on their ID. If someone's identification does not have an address on it, they will need to sign a written oath of residence. Another voter with fully proven ID will be required to co-sign the oath attesting to the voter's address. This will only be required for people whose identification does not have an address. Mr. Speaker, this is one of the reasons why Canadians overwhelmingly support this bill. In fact, 87% of Canadians believe it is reasonable to require someone to prove their identity and address before they can vote. Mr. Speaker, as a resident of Ontario, I recently had the opportunity to apply for a new OHIP card in my riding of Don Valley West. In applying for Ontario health insurance, you must provide proof of citizenship, proof of residency, and support of identity. That's 3 pieces of identification. With that level of scrutiny required for an OHIP card, it is only right to support a bill that requires a similar level of identification to provide for voters in our federal elections. What our government will not support is the opposition suggesting that people shouldn't require any ID to vote. Mr. Speaker, this is another reason why Canadians are on board with this bill. According to an April 24, 2014 Ipsos poll, 70% of Canadians believe it is acceptable to eliminate vouching and require voters to personally prove their identity and address before voting. Our government believes that in a democratic country, all eligible citizens have the right to participate in making the decisions that affect them. The Fair Elections Act will ensure that an honest vote is not denied by fraudulent votes. The fact is, Mr. Speaker, the Fair Elections Act represents a giant leap forward in ensuring that the integrity of the electoral process is in fact upheld. Another important element of this bill, Mr. Speaker, is that it will separate the Commissioner and the Chief Electoral Officer. Quite simply, Mr. Speaker, the Commissioner of Elections Canada should not serve at the pleasure of another official. He should have control over his staff and his budget, and no one should have the power to dictate what he investigates. It just makes sense that the Commissioner should not work for one of the entities he might investigate. This is in keeping with basic fiduciary accountability and standards that government departments and institutions use to ensure their functions are carried out properly and ethically. Our government understands that separating administration from enforcement is vital to upholding the integrity of our electoral process. That is precisely why the Fair Elections Act will house the Commissioner with the Director of Public Prosecutions. Their elections law enforcement will be held under the auspices of a strong Commissioner. We have made him completely independent by giving him authority to investigate offences. The Commissioner will also be afforded full independence with regards to being in charge of his own staff and his own investigations, as well as a fixed term of 7 years whereby he can't be dismissed without cause. We gave him new offences to help him in his investigations, such as obstructing an investigation and providing false information. Our government also supports an amendment giving the Commissioner the unrestricted ability to begin investigations by removing the bill's proposed evidence threshold before the Commissioner may begin an investigation. Working in different entities, our government understands that a line of communication between the Commissioner and the Chief Electoral Officer will be required to perform their duties effectively. As a result, our government supports an amendment allowing the Chief Electoral Officer and the Commissioner of Elections Canada to exchange information and documents. Meanwhile, the CEO currently has the power to adapt provisions of the Elections Act during emergencies. It is highly unusual to give an unelected agency head the power to rewrite any section of an Act of Parliament. Our government believes that the purpose of this power should be limited to protecting the right to vote, which is in line with basic democratic principles. In addition, members of all parties have complained that the rules are unclear and complicated. Complicated rules cause unintentional breaches and intimidate Canadians from taking part in democracy. That is why the Fair Elections Act will make the rules for the Chief Electoral Officer clear, predictable, and easy to follow. The Fair Elections Act will continue to equip the CEO with key responsibilities, especially as they relate to educating voters. That is why our government supports an amendment with regards to the education mandate of the Chief Electoral Officer. The Chief Electoral Officer may communicate with the public, where he advertises to inform electors about the exercise of their democratic rights. He can only do so on how to be a candidate, when, where, and how to vote, and what tools are available to assist disabled electors. Further, the CEO may support civic education programs for primary and secondary schools, something that I know in my riding, Mr. Speaker, is a very important element. Mr. Speaker, I am pleased with the direct manner in which the Fair Elections Act and its amendments will establish ethical and fiduciary investigative independence that is in line with good governance. Another essential element of this bill, Mr. Speaker, is that it will redirect Elections Canada back to its core mandate. As recent elections have shown, Canadians are participating less and less in the voting process. In my constituency of Don Valley West, 67% of eligible voters cast a ballot in the last federal election. Federal voter turnout, however, was even lower at 61%. Since Elections Canada began promoting voter participation campaigns, turnout has actually plummeted from 75% in 1988 to a low of 61% in 2001, where it has stayed. The facts show, Mr. Speaker, that Elections Canada's campaigns are not working. As a result, the bill will amend Section 18 of the Canada Elections Act to focus all of Elections Canada promotional campaigns on two purposes: informing people of the basics of voting, again, where, when, and what ID to bring, and informing disabled people of the extra tools available to them to help them vote and participate in their democracy. Let me be clear. Elections Canada will continue to be the organization responsible for the administration of our elections. However, the job of generating interest will be left to aspiring candidates and parties. Government bureaucracies should continue to focus on administrative functions and leave the duties of generating interest to the parties and the candidates. That is why the Fair Elections Act will allow parties to better fund democratic outreach with a small increase in spending limits, while imposing tougher audits and penalties to enforce those limits. Aspiring candidates and parties, not a government agency, have a duty to reach out to voters, to inspire them and give them something worth voting for. It is time for the agency to get back to the basics while political parties get down to the work they are prescribed to do. Finally, Mr. Speaker, the Fair Elections Act will introduce additional measures to crack down on lawbreakers and fraudsters. This would strengthen the penalties for election lawbreakers. This includes introducing prison time for serious offenders and tougher fines for rule breakers. For example, anyone caught bribing or obstructing an election official could receive upward of 5 years in prison, and anyone who makes a false statement could be fined up to $50,000. Investigators would also be afforded more extensive capacities to fulfill their mandates, such as the introduction of a number of new rules that will close loopholes, crack down on influence of big money, and help stop the election fraud that jeopardizes the system. This includes enhanced protection for voters against robocalls, cracking down on voter fraud by prohibiting vouching, and banning the use of loans used to evade donation rules. In addition, Mr. Speaker, the Fair Elections Act will introduce guidelines for clear and transparent tracking and records retention of telemarketing, which will help prevent rogue calls and voter deception. It will also introduce new measures to track mass calls to protect voters and prevent fraud by creating a mandatory public registry for voter contact services by telephone. The Fair Elections Act will make it an offense to impersonate an election official and increase penalties for deceiving people out of their votes. That is why, Mr. Speaker, the Fair Elections Act is a major improvement of the status quo. It is clear that Bill C-23 is not only constructive, but it also is very reasonable, and we are moving forward. In closing, Mr. Speaker, this bill will make it harder to break the law and easier to vote, not to mention closing loopholes to big money. Election laws will be tough, predictable, but easy to follow. Life will be harder for election lawbreakers and easier for honest citizens who merely wish to take part in their democracy. Our government continues to be a leader when it comes to enforcing greater accountability in politics. When we first took office, we passed the most comprehensive anti-corruption legislation in Canadian history, the Federal Accountability Act. This important legislation increased oversight, cracked down on lobbying, and expanded transparency in government spending. Now, through the Fair Elections Act, we are building on that strong record and helping ensure Canada's democracy remains strong and its integrity upheld. The Fair Elections Act is an important step forward towards greater transparency and accountability in our elections. These meaningful changes would help strengthen Canada's electoral system and help ensure that our democracy remains in the hands of everyday Canadians. That is why I vote in favour of the Fair Elections Act, Mr. Speaker, and I hope my colleagues on both sides of this House will join me in doing the same. Thank you, Mr. Speaker.
Question et commentaire, l'honorable député de Pierrefonds-Dollard.
Président, merci à mon collègue pour son discours. Il a parlé un peu plus tôt de pouvoirs qui permettaient de faire enquête en cas de fraude électorale. Et je suis plutôt surprise parce qu'on n'a pas la même lecture de l'efficacité ou des mesures que ce projet de loi-là donne effectivement pour s'assurer de pouvoir enquêter efficacement au sujet des fraudes électorales. D'abord, il faut reconnaître, je pense que tout le monde dans cette Chambre reconnaît qu'il y a eu une fraude électorale importante en 2011 et qu'il faut donner ces outils importants à ceux qui en ont besoin pour s'assurer de faire la lumière, parce que non seulement il y a eu fraude en 2011, mais on n'a toujours pas été capable d'identifier plusieurs des responsables de ces fraudes-là. Alors, en revisant un peu certains témoignages, je me demande, par exemple, le commissaire aux élections fédérales, dans son rapport annuel 2012-2013, parle de la nécessité de pouvoir obliger quelqu'un à témoigner. Il y a aussi le directeur général des élections du Canada, qui parle davantage de pouvoir, notamment pour demander des pièces justificatives pour ce qui est des dépenses déclarées pendant des campagnes électorales. Ces demandes-là ne se retrouvent pas dans ces 23. Est-ce que mon collègue considère que ces gens, que le directeur général des élections du Canada et que le commissaire aux élections ne connaissent pas ce de quoi ils parlent? Est-ce qu'ils pensent qu'un parti politique est moins partisan que ces experts indépendants qui font des demandes de ce genre?
The honourable member for Don Valley West.
Well, thank you, Mr. Speaker, and I thank my colleague for her question. Respectfully, I disagree with the premise on which the question was launched. The Commissioner and the CEO, Mr. Speaker, are being separated according to the bill. Under good governance, fiduciary responsibility that's now entrenched in so many parts of our society, it's important that that premise be maintained and underpinned in everything we talk about today. We do that from the perspective of separating the Commissioner in managing the process, the CEO in managing the process, and the Commissioner in managing investigations, etc. The Commissioner will have the same powers as he does today and the same powers as the RCMP. We agree that The Commissioner must be free to do his job without impediment, and that's why the separation of the two, falling with the Commissioner now working under the Director of Public Prosecutions, and that way I feel very, very reasonably being able to operate in an unfettered environment and according to the fiduciary standards, again, that are inherent in our society today. Thank you, Mr. Speaker.
Question et commentaire, l'honorable député de Lac-Saint-Louis.
Thank you, Mr. Speaker. I just want to draw attention to one aspect of the member's speech when he talked about what is required to obtain an OHIP card. I'm just wondering if we're not comparing apples and oranges here. When it comes to OHIP cards, you know, we know that unfortunately people over the years have tried to defraud OHIP, but it's a very different case from trying to vote illegally, because in the case of defrauding OHIP, there's an actual financial benefit to the person who would defraud the system. But when it comes to committing election fraud, when we're talking about one person who is voting who would not have the right to vote, you know, it's not benefiting that. First of all, it's not a financial benefit, and secondly, it's not benefiting that person directly. It's benefiting maybe that person's candidate or party or what have you. So I don't think it's a fair comparison, and I'd like the honourable member's comment on that.
The honourable member for Don Valley West.
Well, thank you, Mr. Speaker, and thank you to my colleague. Let me be clear. I didn't want to use the comparison to necessarily say that one equals the other. Clearly, there are differences between OHIP and the right of a voter. In fact, I believe the privilege and the right to vote is more important than any other democratic standard we have available to Canadians in this country today. I merely pointed out to the degree that from an identification process, the Ontario Health Insurance Program has rigid rules and processes in place where you simply can't get a health card without three very well-defined pieces of identification, including photo identification. I believe very consciously that our right to vote is the greatest privilege we as Canadians have today. And so to that end, I believe that we must take very, very seriously the identification processes, the issue of eliminating vouching to the degree that we have for identity as a mandate to ensure that we uphold the very highest level of electoral standard that we possibly can. And clearly, I believe that I've outlined that in my presentation today. So thank you to the member opposite.
Questions and comments? Honourable Minister of State for Sport.
Well, thank you, Mr. Speaker, and I want to thank my colleague for an excellent speech, an excellent interpretation of Fair Elections Act, and it's greatly appreciated by Canadians all across, traveling around, talking to them. Identification he talked about. One thing I would like to ask my colleagues is, when he went back to his riding, consultant with the people who elected him, what were their views on this Fair Elections Act? Thank you.
The honourable member for Don Valley West.
Well, thank you, Mr. Speaker, and thank you to my honourable colleague. And a very good question, because I was involved actively at the grassroots level talking to my constituents. And clearly there's been opinions on both sides, but far exceedingly, any time I talk to my constituents in Don Valley West about vouching, they mirrored or exceeded the 87% of Canadians that were polled in the Ipsos poll of April 24th that said that it is a reasonable expectation that identification should be proven by the voter. And so when I talk to Canadians within my riding across the City of Toronto, in fact across Canada as I've had opportunity, including, I should add, leading in my riding, I led a roundtable discussion on this very issue at the Canadian National Institute for the Blind to address issues of disability voting or voting for the disabled, in this case the sight impaired and the blind. And clearly our position on this is well entrenched in the minds of the people that I talk to, and they're very, very supportive. So thank you to that question.
Question et commentaire, l'honorable député de Carmichael.
Monsieur le Président, j'apprécie le discours de mon distingué confrère, avec qui il m'est toujours plaisir et agréable de travailler. Mon problème, c'est que cette loi est présentée sans consensus de ce Parlement. C'est un problème parce que c'est la première fois dans l'histoire du Canada où un parti politique présente une loi qui lui est, excusez-moi de vous le dire, extrêmement favorable à sa réélection. Généralement, la loi électorale, pour être crédible à l'ensemble de la population, doit non seulement être indépendante, mais il faut aussi qu'elle ait l'apparence d'être indépendante. Et à ce niveau-là, cette loi C-23 rate admirablement son objectif. Tous les intervenants, tous les éditorialistes, tous les représentants de différents barreaux du Québec, tous les intervenants en question électorale ont dit que cette loi était mauvaise. On a présenté certains amendements, Dieu merci, parce qu'on est passé d'une loi inacceptable, antidémocratique, à une mauvaise loi. Mais elle reste toujours aussi mauvaise pour le simple fait que personne autre que les conservateurs l'approuve. Est-ce qu'ils trouvent ça normal qu'une loi aussi importante que la loi électorale soit présentée sans consensus?
The honourable member for Don Valley West.
Well, thank you, Mr. Speaker, and thank you to my colleague opposite. Mr. Speaker, in my presentation, in my speech, I talked about the extent to which the committee opened the doors and heard the views of Canadians, and many eminent and very well-respected Canadians who took the time and energy to come to Ottawa and to present their testimony as witnesses at committee. In my numbers, just to reflect briefly, the committee had a long and extensive study with 15 meetings, accounting for roughly 31 hours of study. This was no trivial exercise. This was an extensive study in the House, and there have been 72 witnesses that appeared at committee. And I should also mention, Mr. Speaker, that to my honourable colleague's comment, we allowed every single witness that the opposition brought forward to committee to testify. I think that's an incredible statement. Now, they ran hearings across the country, and they brought a series of witnesses that that the government, the committee itself, opened the doors to and clearly heard from. I believe, Mr. Speaker, that democratic process has been well entrenched in this bill, and that the hearings of Canadians, hearing their opinions, has more than adequately been met. Thank you, Mr. Speaker.